SHERRONE MOORE. Counsel, please state your appearances for the record.
Good afternoon, Your Honor. Katie Rismersky for the people.
Good afternoon, Your Honor. Ellen Michaels on behalf of SHERRONE MOORE, who is present in court.
Your name, sir?
SHERRONE MOORE.
All right, thank you. All right. Date and time set for probable cause conference. What do we need to do today?
I've had the opportunity to talk with the prosecutor. There is outstanding discovery that we need to have before we can proceed to exam. So we're asking to adjourn the probable cause conference for 30 days to receive that discovery. In the discovery, we're talking about our phone records and Title IX documents.
Okay. Are the people going to be in possession of Title IX documents or have access to those? I guess.
It's a very good question, Your Honor.
Thank
My
you.
best understanding.
I usually ask good ones.
You
but
do.
Go ahead.
This court always does. My best understanding in the moment is that this is not a Title IX investigation per se. My information is coming in real time, as they also say. It was a complaint apparently to the Office of the General Counsel. I have just moments before we came onto the record been informed that there is no written report. That is my best understanding. Whether or not there is some other kind of investigative information that exists has yet to be ferreted out. That effort, that process is ongoing. Ms. Michaels is correct in the aspect of phone records are being sought. All of the, just so the record is clear, all of the evidence and discovery that we have has been furnished to defense, but the investigation is ongoing.
Okay.
Whether or not 30 days is sufficient is a live and good question.
Okay, well, and let me just make sure that I'm clear. Whether 30 days would be sufficient for phone records is questionable, or for everything that Ms. Michaels indicated? Yes.
I believe my thought was everything, but I think that also applies to the phone records. Quite frankly, Judge, I don't know what that timeline is. I can try to find that timeline out and communicate that to the court and counsel, but I don't have that.
Okay, and I guess I'm not, what I don't want to get to, I guess, is a point where we're at a certain point, it may be ready to be set for exam or do whatever, and everything that these records, I'm presuming, Ms. Michaels, that you're saying from the U of M, that are records from the U of M.
Correct. It's our understanding that when you just step back a touch from the actual incident, there were statements made and things done earlier that day to the U of M, statements made by the complaining witness that are going to be important to this investigation because her credibility will always be at issue, and different statements she made to different people will need to be evaluated. So those statements are important.
Okay, I get that, but those, I mean, aren't those documents or statements that you can get on your own, or?
That's a great question. I can issue a subpoena if the court is willing to sign a subpoena. I will send a subpoena myself, but I do know, based on the police reports, that the prosecutor's office is also seeking those documents, and in my experience, documents, people are much more ready to turn over documents to a prosecutor's office than to a defense attorney.
We may quibble about that, but
Yeah,
I don't.
Depends on one's view of life.
But I take no issue with discovery flowing through us.
Yeah,
in terms of
right.
this
I don't have a problem with that either. It's just, I'm trying to figure out if the request is made. So, because are you attempting to try to obtain those documents?
I am.
Okay. And then, once you obtain them, if you do obtain them, you're gonna inform council or provide them to council.
Immediately.
Gotcha.
One more thing, Your Honor, for due diligence sake, maybe I should submit to the court a subpoena for signature, and of course I'll serve the prosecutor, and I can also submit a subpoena requesting those records, having them returned to the court.
Well, having the results come to the court.
Correct.
Okay, and then we would, okay, I don't have a problem with that if we're the go-between that it comes here and then goes out. I don't necessarily have that, so unless there's some legal objection to it, if you submit a subpoena to the court, I would sign off on it, I guess, to try to get this, so we can get this thing moving. 30 days. So, there's also, and just so that's the discovery issue. Today, I guess that was filed a motion to quash.
That's correct. Earlier today, I, at the court window, filed a motion to quash the arrest warrant and a request for a Frank's hearing. I have a signed copy. Prosecutor, and we will be asking for a hearing date on that motion.
Okay, do you want two separate dates? I mean, how fast do you want, well, first of all, I mean, the people have to answer, so.
Sure.
I guess, how fast do you want this?
This can,
And what I'm indicating to you, Ms. Michaels, is I could set the motion along with the PCC, hear it all at that time. Or I can give you a date for this, separate and apart from the PCC.
I would like a date separate and apart. This motion is not determinative of those records. It is prior to those records. So a date to hear this motion prior to receiving those records would be our request.
Right, but, I mean, presumably, actually, you're then talking about 3 hearings, because there's gonna have to be a hearing on the motion to determine whether or not you'd be entitled to a hearing, an evidentiary hearing. Then, if necessary, you'd have to set the evidentiary hearing. And then we would also have the PCC.
That is accurate. So a suggestion may be to, whatever the court desires.
Oh, you don't want that. You know, go ahead, okay, that's fine.
You know, this is a lot. So in the expedience, it's discretion as to how you want to set
For
things.
that part of it, but we'll try to get through it as quickly and as expeditiously as possible. But the people have seen the motion. How long are you going to need to respond to the motion for the first part of it?
So although I was aware that a motion was filed this morning, I was not served with a copy until moments ago. I have obtained a copy through the court file prior to being here right this moment and have had an opportunity to begin to flip through it. I have not consumed it in its entirety.
Right.
How long to respond was the court's question?
Yes. For the first part of a determination as to whether or not you're hearing in this case.
Court's pleasure, but at least a week.
At least a week. And well, maybe they have to set it on a date. Monday. If I give it for 10 days. I'm just gonna give her a raise again, 10 days. And then just give me a week to go through everything, so around this time. Okay. Up here, so. Got it. Okay. Will that work?
Yes, that will work.
All right. So with reference to the motion, I'll have the prosecutor's response will be due by maybe longer than a week, February 2nd.
Thank you.
February 2nd, 2026. I will then set this for hearing on the motion. For February 9th, 2026, at 1 p.m.
Your Honor, may I speak up?
Yes, go ahead.
In the moment, I have a murder case set to start on that date.
That's-
That may
that's-
change, even within the end of the day today, that may get moved. But in the moment, that is day one of the murder trial.
That's day one.
Yes.
That's not a good date for me either, Judge.
16. Just give me a date and let's see what we can figure out. Well, Tuesday. So,
Tuesday the 17th at 2 o'clock.
Should be fine.
That works for me.
at what time?
2 p.m.
All right. So the motion will be set for February 17, 2026. You said 2?
Yes, sir.
At 2 p.m. Okay, and that will be an in-person hearing. We then, in understanding that, depending on the result of that motion, there may be another date that is set. But I'm not going to deal with that at this point because a determination has to be made. So I'll adjourn the probable cause conference. And folks, knowing I'm not really going to care about the date itself, but with some of the logistics that come along with this case, I have to because of other docketing concerns. Will March 19th then work? I realize that's a little bit longer than what you asked for, but we're going to see each other on the 17th. And then I would adjourn this out to the 19th, hoping that all discovery, at least at that point, is clear.
That works for the defense.
Works for me as well, thank you.
All right. So probable cause conference will be adjourned to March 19th, 2026, 9 a.m., whereas your invite indicates. Is there anything else from either side?
Nothing for the people.
No, Your Honor.
All right.
Thank you very much.
Bond will continue.
Thank you.
Thank you.
I'm Andy Dominiani. Thanks for watching. If you like this video, we've got much more to see. So take a second and subscribe to our channel.